Hey, everyone, and welcome back to the Oxendine Law Podcast. I'm your host, Jared Oxendine, along with my co-host, Christine Palmer. And with over 34 years of combined experience, we're here to tell you what you need to know, tips, strategies, everything you need to be successful in your divorce case. And something unique about us, just very quickly, we have a team of 5 attorneys. We've got a house full of paralegals, legal assistants. So you've got a true team that's behind you. You always got somebody you can reach out to when you call the office about your case that knows about your case and can answer your questions. So today we're talking about an important topic, and that topic's going to be protecting your assets in a divorce and how assets are actually divided in a divorce. As we all know, divorce can have a huge impact on your finances. So understanding how to protect what's important to you is absolutely essential to your happiness when you walk away, and your freedom and your financial security when you go through the divorce process. So we're going to walk you through the basics of asset division, give you strategies to ensure your financial success. So to get started, let's first talk about marital property versus separate property. I'll start with separate property. Separate property is whatever you bring into the marriage. It can also be something you receive during the marriage from a third party. So let's say you get an inheritance or you get a gift during the marriage. It only goes to you, doesn't go to your spouse, but it's gifted only to you, or it's inherited only by you during the marriage. That also is your separate property. And so when I say separate property, it means that in the event of a divorce, whatever your separate property is, your spouse has no claim to it. Now, I think the most important thing to discuss, Christine, about separate property before we talk about marital property is how to make sure that you keep your separate property, because we
Exactly
see
it.
this mistake all the time. And everybody thinks marriage is forever, and they don't want to think about what I'm going to tell you need to be thinking about because they think they're never going to go through a divorce. But guess what, folks? The divorce rate is super high. It's over 50%. So as much as in love as you are right now, if you're listening to this podcast, you're either thinking about it or you know somebody that has. And so the divorce rate's super high. You've got to protect yourself. Separate property. When you bring that into the marriage, you've got a retirement account. You've got a bank account. You've got a house, whatever. You have to keep that in your separate name. If you get married and you add your spouse's name to the bank account, or you add them to the deed. We see that all the time where somebody will refinance and they'll add their spouse's name to the deed. You have now converted your separate property, where your spouse had no claim, to marital property. And people always hate to hear about that when they meet with us, don't they, Christy?
They do, and that's anything. So I had a case, it's been many years, and my client was joint on a bank account. She truly did not even know it. When I tell you she had no idea, we learned this through discovery. She told me, "My husband inherited a large sum of money when his aunt passed away." It was, a couple $100,000. And she said, "Now we've pulled from it a few times throughout the marriage. We redid the kitchen. That was about 40 grand. We did pull from it, and a couple other things we've pulled out to invest into our home, but it's in his separate account. It's his." And I said, "Well, unfortunately for you, he did the right thing. It's in his separate account. It's his. You're right. You have gotten the benefit of it throughout the marriage by improving the house, which is completely marital." Discovery comes back. He was wrong. Her name was on that account. She didn't have a debit card to it, but it was a joint account. So those are now commingled funds, and she was entitled to half of those. So names matter. These little details matter. If you receive it, just keep it separate. You can use it still in your marriage. Continue to spend it as much as you want. Just whatever's left, whatever you're not using, keep it separate.
Well, and I'm glad you brought up commingling, because that's a big no-no too. So let's say you get married and you've got this bank account. I'm just going to use a round number. You got $100,000 in your bank account. And let's say you don't even put the other person's name on it, but you start adding money to that bank account during the marriage. So you're making money, she's making money. Maybe you're the only one making the money. It doesn't matter. Anything you earn during the marriage is marital, and you're adding it to that $100,000. And then let's say during the marriage, you start spending money out of that bank account. And then you come sit down with me and you're like, "Hey, we added probably $100,000 to this bank account during the marriage, but we've spent $100,000. Guess
First
what?
out.
First in, first out rule, it sucks. But the first in, first out rule says whatever money was in the account first is the money that comes out of the account first. So that $100,000 under the example I
Your
just gave,
separate 100.
your separate 100 is actually what y'all spent.
Yeah.
And
guess
the
what?
marital, Yeah, the marital is what's left. Best pointer we can give you is keep your separate properties separate. And most of the time, your spouse will understand that. They understand that you accumulated these assets before you got married. They're not expecting you to immediately put their name on it. If they're pressuring you into doing that and they're saying, I'm not going to marry you unless you put my name on the bank account or my name on the house,
Red.
then you probably don't need to get married. That is a red flag. You're doomed from the beginning. So most of the time, people understand that you want to keep your stuff separate and they don't have a problem with it. Please keep it separate, whether you bring it into the marriage, whether you inherit it during the marriage, whether it's gifted from your aunt or uncle just to you during the marriage, keep it separate. You'll be good to go. Now, Christine, marital property.
So marital property is anything, any asset which is obtained during the time that you're married. That can be real property. That's your income that comes in every day. That's every bit you're putting in that retirement account. That's the secret account that your spouse doesn't even know about. Keeping it secret does not make it separate. Anything that is earned during the marriage is marital and subject to division. If you are the sole and only earning spouse and he or she has never worked, never earned a dime, never paid a mortgage payment, never paid a dollar toward the light bill, we hear all these things, never contributed, she shouldn't get half of the money when I earned all the money. She's lived in my house for free for 10 years. She still gets half of everything that exists because you created that situation. You've allowed it. If you didn't like it, you could have got divorced 6 months in. There's nothing to divide 6 months in. But when you allow that to go on, I mean, Jared and I had a client we both worked with in the past that was just flabbergasted to learn this information. She was female. So this is kind of a reverse of what we normally see. She had worked, high-powered executive. She had accumulated all these assets and she'd married a younger man. So at the time, it was fun, a good time, but he just had lived free in her house and spent her money. And after all this that she had saved and bought the nice house and everything, he was entitled to half of everything. And she just didn't want to hear it. I don't know how many times we had to say it and tell her over and over, he's entitled to half. It was like, but how? Like, well, that's the law. But how? But I don't understand.
Yeah.
So, yeah.
What's marital is marital is marital. So, all right. So we've defined marital, we've defined separate. Let's talk about how we divide those assets, how we value those assets. So before we divide, let's value. All right. Valuation is pretty simple. It can get complex, but we like to keep it simple. We think we're experts. Frankly, I know we're experts at this. So we make it sound very simple, but sometimes it can be complex. Simple things would be valuing a bank account. Okay, that's pretty simple, right?
How much is in there? There's your value.
That's right. Homes, we get appraisals. Now, sometimes we can agree that we'll just look at Zillow values. So I'm seeing that a lot where people will go online and they'll look at Realtor.com, Zillow, Trulia.com, and the parties will agree that, yeah, that's what the property is worth, and we don't have to incur the expense to actually get a formal appraisal done. But sometimes we need formal appraisals. That's easy to do. It's a quick process. It's a pretty reasonable.
$200, you get a number you can't really dispute.
Now, the complex valuations, I don't know how complex we want to get on this. A tracing situation, those can get complex, and especially when you have a business. So, Christine, I'll let you talk about tracing in a second. I'm going to talk about businesses because I love business cases. I don't know why. I just love it when we have a business because, we have successful people and they're responsible and they're usually rational and they're reasonable. And they've done well for themselves and they're trying to protect their financial future. And when you have a business, you actually have a lot on the line. So, we can get businesses valued just like we can a house. And we have experts. We have a whole treasure trove of experts, forensic accountants, business evaluation experts, CPAs that actually can do evaluation of the business. So if you are the spouse that doesn't own the business, now, again, if the business is starting during the marriage, it's marital.
It is.
And
people don't understand that a business is a marital asset subject to division. Chances are we're not going to sell the business so that we can divide it. But yes, that is an asset. That business is an asset.
That's right. And if you are the person that's not been working in the business, that means your spouse is going to keep the business. But if you're smart, you'll get a valuation of that business done because they have to buy you out for your share of the value of the business. And our experts will go through the books, through the financial accounting, accounts receivable, accounts payable, inventory, contracts, goodwill, the whole 9 yards, and come up with a number of what that business is worth.
But remember, that's also a value. How often do you have the party who doesn't work the business, doesn't own the business, that says, oh, that business is worth probably like 5 or 6 million. And the valuation comes back closer to 1. Why? Because gross profits are not the value of the business.
Correct.
So, yeah, we often see that. Well, I saw the business tax return. It showed millions. Okay, that's not the value of the business and industry in which the business is. It's huge. I mean, what's the difference between a State Farm agent, and then someone who actually owns like a company that has inventory, that has products and things. The valuation is going to be hugely different.
That's right. And that's true. What the business is grossing goes into determining the valuation, but that does not equal the valuation. And so once we get that valuation, the business owner most likely will be buying out their spouse so they can retain the business. And there's a lot of different ways to do that. You may get a larger share of the other assets. You may get paid out monthly.
Sure.
You may get X number of dollars per month until you receive the full amount of the payout. Now, that's from the standpoint of the person receiving the buyout. From the standpoint of the business owner, there is a huge strategy that I see that gets missed all the time, and I almost feel like we shouldn't give our secrets away, Christine, but I'm going to do it because we're like to be truthful and honest. One of the things I always make sure my business owners get when they are buying out their spouse is a discount, because you should get a discount.
Yeah.
And I see that mistake made all the time where the valuation comes back, and let's say the business is worth $1 million, and it's a 50-50 division. We'll talk about again how we divide, but let's assume it's a 50-50 division. $1 million valuation. They just agree to give their spouse $500,000, which is half. Why is that not good? It's not good because guess what? That business owner has to maintain that business as a going concern. They have to keep working at the business. They got to keep selling widgets. They got to keep paying expenses.
Insurance on that business, employees in and out.
You know, they can't just close the doors down because they owe their spouse $500,000. So almost always courts will give a significant discount from the valuation of the business. When I say significant, as much as 40 to 50%.
Yeah.
I
would say about 35 standard, and depending on the industry, up to a 50% discount.
Absolutely. So if you're the business owner, you cannot miss out on that tip and strategy. That's probably the biggest tip and strategy I have from the business owner. There's others. Our podcast can only last so long, but that's the major mistake that I see happen that business owners need to take advantage of. How do we divide assets? Christine, our principle is equitable division. What does equitable division mean?
Equitable is what is fair and just in these exact circumstances. I love that we're an equitable division state because, in my opinion, it makes the most sense. A couple factors go into that. Equitable meaning what's fair. So we look at each party's earning capacity. How often do we see this? One party is consistently earning $350,000 a year. The other party's never worked. So if you took the pie that these parties are splitting and you cut it in half, and you give half to 350 and half to 0, 350's never eaten that pie, because he's still earning 350.
Mm-hmm.
And 0 is going to have that pie eaten by the end of the day because that's all she has to eat. So it doesn't make sense to divide that in half. That's an equitable argument. She should receive more because he's going to replenish at such a greater rate. It doesn't make any sense to punish this person when everything that we're dividing is marital. So that's one equity argument of why one person should receive more than the other. We oftentimes see people argue conduct in an equity argument. I think that's not as substantial as the other arguments, like the replenishment rates. But if there really is bad conduct, that can be considered as well. If you are misusing funds, misappropriating funds, the first thing everyone thinks of is you're taking your girlfriend to Cabo and spending this money. But it's not just that. It's gambling. It's bad investing. How often do you see somebody who just put a bunch of money in a random Bitcoin or something and didn't know what they were doing, thought they were smart enough, day trading. I want to get into day trading. And they've just unilaterally wasted these marital resources.
Without their spouse's knowledge.
Without knowledge.
Which is huge.
At all.
The other spouse does not know this person's out gambling or day trading and just spending all the money away. And so that would be a conduct issue to where when we're dividing the asset, that person could argue, hey, it's not fair that I only get half of what's left because they have wasted most of our marital estate and I didn't even know about it.
Sure.
So when we say equitable revision, folks, equitable usually means 50-50.
Yeah.
But it doesn't always mean 50-50.
Sometimes that's not fair.
And if the circumstances in the case, for whatever reason, are not fair to do 50-50, then either side can argue that they should get a larger share of the division of assets. And I think Christine did a good job of pointing out a couple examples of how you can get a larger share of the assets. Of course, adultery is the big one that we see all the time. Somebody will come in and say, my spouse has been cheating on me. They need to get less.
I want everything.
I want it all. I want it all. Give it all to me. It's not fair. And that's interesting. And we could probably talk an hour about this, but I'm going to spend maybe a few minutes on it. Back in the day, people got hammered.
Yeah.
For adultery. I mean, when I first started practicing, if you could prove adultery, that judge was guaranteed to give the non-offending spouse, you're going to get punished. You're going to get more than half. Now, it's kind of, unfortunately, I guess it's a function of society. There's just so much of it out there going on, which is not good for society, but a lot of adultery out there. Judges see it a lot. And unless it's an egregious case or egregious circumstance, judges still usually are doing a 50-50. Now, if your spouse has been out spending a lot of money on a boyfriend or girlfriend, trips, jewelry, clothes, they're neglecting paying your expenses at home, treating you badly, and have basically abandoned you and taken off with the girlfriend or the boyfriend, different story. I'm still seeing judges penalize people in those situations. Or if we have a large estate, if you can prove a long-term relationship that has been hidden from the other spouse for a long period of time, and there are significant assets to divide, and especially if the person committing adultery makes a lot of money or more than the non-adulterous spouse, then I will see judges give a larger division. But we're talking, 55%, 60%. It's been a while since I've seen it get up as high as 70.
The bigger asset, when there's more to divide, that percentage is less of a hit. I mean, if these parties are of reasonable means and they don't really have a lot, the court's probably not going to punish an adulterer to the point of like, it's not so bad that you should be destitute after this divorce. We'll just 50-50 and, do better. But if that's the situation, you probably didn't have the money to spend on the spouse on the girlfriend or the boyfriend to begin with. But you're right. It's the ones where these people got married and they've been married for 30 years. And this spouse believed that whatever's sitting in that retirement account, that's what I'm going to have access to when I retire. So that's the plan that I've made. And only his actions have made me not been able to execute that plan. That's where we see it more like the retirement asset thing. Okay. Right. So I know that on purpose, we set a goal. We sat down with our financial advisor and our goal was to have 3 million in this account by this date. And we achieved it. And we're actually above that. So I never believed for 1 second I would have 1.5 million when I got of retirement age because this 3 million was our goal. And so, right. So making that argument of I made this plan, he's the reason that it's screwed up. I shouldn't have to suffer because of his mistake. That's an argument, a solid argument for a higher percentage of equitable division.
That's right. So folks, just basic rule of thumb here, assume a 50-50 division, but if there's a circumstance in your case where it's not fair to do 50-50, then ask your attorney, to give them your fact pattern. And if you hire the right attorney, somebody experienced like us, they'll be able to look at you confidently with a straight face and say, yeah, I think that's a good reason that would support you asking for a larger share of the assets. Or also be honest with you and say, hey, I'm glad you told me that. It's good to know. We'll put some pressure on the other side. But most likely is not going to tip the scales if a judge is hearing the case.
Right. Plan for a 50-50.
That's right.
Or don't waste your resources over me trying to go argue because chances are it's going to be 50-50. So let's preserve the marital assets that exist and split them 50-50.
That's right. All right. Safeguarding financial assets. This is one that I see come up a lot from this particular standpoint that I'm going to open with. And it's the spouse that has been financially controlled and they've been financially micromanaged. And they are so concerned that if they file their divorce case and once their husband or wife gets served, that they are going to just cut them off completely financially. They're going to take credit cards away. They're going to stop depositing the money in the joint account. And they're going to make life miserable on them to where they cannot pay for anything, much less an attorney.
Gas in the car. I can't feed my kids.
And it's amazing how many people are out there in those type of situations where they are just that micromanaged and controlled, not only emotionally, but also financially. So every time I see that fact pattern in front of me, I hope and I pray that the answer to the next question I'm going to ask them is yes. And the question that I ask is, what money do you have access to right now? Do you have access to any sum of money in a bank account that you can go ahead and take out to use as a safety blanket if that person cuts you off?
Right.
And most of the time, clients will take that advice. Sometimes they don't. They always wish they would. And the example I'll give is very recent. It was a female client representing the wife in this case. Husband was financially controlling, and she had access to a couple $100,000 in her bank account. And I told her, before we file this case, go into that account and take out half. Leave the other half in there for him.
Mm-hmm.
Now, don't go out and spend it on jewelry, vacation, new car. You're holding on to that. You're safeguarding that money. You're preserving it. But if he cuts you off once we file this case, now you've got to pull money that you can pull from to pay for your personal expenses. So that is a big tip on what you can do to safeguard the assets. And keep in mind, if you're in that type of situation where your spouse is financially controlling and you've got access to that money, we're going to get a hearing. You don't have to spend that money down. We can get something called a temporary hearing in your divorce case where the judge, within a period of 30, 60, 90 days, depending on the county, a judge will set a court date for you to come in and have a temporary hearing to get a temporary order in place that makes your spouse pay for the expenses they've historically paid. So if they've historically paid for the mortgage and utilities and given you money for gas and clothing and, going to the salon, whatever your personal expenses are, the judge will put an order in place that requires your spouse to continue to contribute to you financially. But between now and the time we get in court, it's always nice if you've got that money to fall back on if your spouse has cut you off.
Sure. And if you are that spouse that isn't the controlling one, right? You're just being controlled. Remember that just because you don't have a debit card does not mean you don't have access to an account. If you know where he banks and you walk into any Bank of America, Wells Fargo, you walk in and you say, "This is my name. Do I have any?" You'd be surprised how many times it is a joint account and you have access to that. If you show them your ID and that's me, you can withdraw it right there from the bank and take out half. So I've had clients discover that they didn't even know they were on the account. They just, well, he moves money over into this or a prepaid I've seen prepaid debit cards. I've seen just, the small account that does have a debit card and he siphons money in. But a lot of times the bank account is a joint account. Just because you don't have a debit card doesn't mean you're not on there. So walk into the bank and just ask, "Hey, do I have any accounts here? Here's my name." They'll do it.
That's right. And it's okay if you don't have access to that money. I mean, not everybody's in a situation where they have access to $100,000 they can pull out.
Right.
It's okay. We will use that to your advantage. We'll still get the case filed. We'll get it served. We might file a motion for an expedited hearing with the court.
Right.
And we have examples now where after your spouse got served, they cut you off financially, right? I mean, we've got where they've shut off your credit cards, or we've got text messages or emails from them saying, "I'm not going to give you a penny. Good luck. Move forward with this case. You're going to get nothing." And that's usually persuasive enough for a judge to give us a very quick hearing to get that order in place to require your spouse to pay what they should be paying.
Sure. And what we see often as well, person comes in and they say, I know we've got money. I know we've got, he talks about it all the time. I know we've got money. I just don't have access to it. If you are able, even if it's not from a joint account, if you are able to secure a loan or a gift from a relative, if your parents are willing to put up that initial retainer amount for your attorney's fees to get the case started, OCGA 1962 specifically says that the higher earning spouse is required to contribute toward the lower earning spouse's attorney's fees. So a lot of people think that means they're going to get an order that says he owes me $10,000 for attorney's fees. Sometimes we get that. What it usually means, though, is this is a marital pool. We've talked about marital assets. Anything earned during the marriage is marital. So there is no his money paying for my attorney's fees. It's really gaining you access to what are joint funds. Even though your name may not be on an account, those are joint funds. So we can use that path to the court to get you reimbursed for the loan that you have taken from your parents or the gift that you got, or if you did have a separate account. I know people that sometimes they have a separate account that has maybe, $20,000 in an account. Like, that's all I have to my name. That's literally all I have. Okay, well, if you have to pull from that, we're going to get that replenished because you're owed it out of the marital estate. So just because you don't have immediate access, we also have ways to get you quick access to the extent it's necessary.
That's it. All right. So let's say you're the person that has access to the money. Every single penny is, you know where it's located. You know what everything's worth. Any tips on how they can safeguard? I've got something. It's controversial, but it's legitimate, and I'll just go ahead and say it. Let's get a little controversial. I've had plenty of people come into my office in those situations where their spouse is just kind of in the dark on the finances, and that's okay. I mean, that's the way they've run their marriage. But for whatever reason, my client, who knows what everything's worth, they may even have a business, doesn't think it's fair to give up half of everything they've got. So what's the advice I'll give to those people? Let's do some planning. Come in, meet with me before we even file. Let's talk about what your maximum exposure is. If your spouse knows about all the assets, if they're fully disclosed in the divorce process, which you're required to do, if you go through a formal contested divorce, then this is what you're going to pay. Potentially, they're going to get half of this and half of that. And if your business is worth this, and they potentially get a payout of Y. And so we sometimes can get our ducks in a row and then put together an uncontested settlement proposal that we send out to the spouse, and it looks nice. The spouse is saying, "Oh my gosh, I didn't know we had this. I'm getting how much money?" And they sign off on it, and it's an uncontested divorce, and the case is finalized. Now, it's controversial. because you can argue that, it's not fair to the person that just took less than half. But I would also argue that that person's made an intentional decision that, hey, this is enough for me. In other words, if I'm leaving some money on the table, it doesn't matter. I want closure. This works for my financial situation. I want to move on down the road. And I appreciate you making this offer. And you know what? I'm going to sign off on this and get this done
To be
quick.
done with you today? You're telling me, I don't know how much you have, but you just told me you're going to give me $250,000 to walk away from you today. Sometimes that works.
It does work. You'd be
Doesn't it?
surprised. Now, I don't let my clients do that.
Seems too good to be true. It is.
And let's just disclose that. If you get an uncontested settlement offer in the beginning of the case, before you hire an attorney, you need to go meet with an attorney.
Oh, 100%.
And if you don't know what the finances are, you need to get copies of all the account statements and full financial disclosure before you sign or commit to anything. Absolutely.
Yep. But another way that you can sort of safeguard those financial assets, let's say that you already know that the uncontested trick's not going to fly. I will meet with my clients and go ahead and tell them, let's look at your total financial picture, what is available as assets, but what do you have in debts? Because we can only divide what's there. Should you go ahead and pay off every credit card, pay off your vehicle, maybe pay off the house? You can't divide what's not there. And those assets are going to be divided ultimately. But if you want to minimize the exposure of the actual and walk away from your divorce debt free, maybe you have some less money, but so does she, so does he, and you have no debt. So those are there's nothing wrong with that. There's nothing wrong with satisfying debt up front. A lot of us carry debt because it makes sense at certain times to carry certain debts, and you're flexing your credit. So I took out a HELOC, and I'm just, paying it back. I'm making what makes sense. And in a marriage, and we're a dual income household, maybe not, but it's making sense for you now. One way to preserve those assets is to use them to your advantage and go ahead and get yourself out of debt completely. Liquidate this, liquidate that, or pull this. Let's get you debt free.
Yeah. Or if you're a business owner, you've got a big expense that you're about to have to incur in your business. It might make sense to go ahead and incur that expense, because once you file for divorce, those major expenditures like that, unless they're in the ordinary course of business, are not going to be allowed to happen.
Yep.
So go ahead and incur that business expense, because any debt or any assets that are legitimately used for a legitimate business expenditure are going to lower the value of that business. Now, one other tip I'll give, let's say you're the person that knows all the finances and you don't want to be tricky. You want to do a fair division. I mean, I see that all the time, and I admire that. Frankly, that's what I prefer. Most people come in the office, they're like, you know what, we've had a long marriage. I want what's fair. I want to be fair to her. I want to be fair to me. Or it might be a situation where your spouse also knows what all the assets are anyway.
Yeah.
One smart thing to do, which I love doing, and I've been doing this many times, is we'll try to do like a pre-filing mediation. So, maybe both parties have attorneys, and the attorneys get together and agree on what financial documentation they need to exchange. If a valuation or an appraisal needs to be done, we go ahead and get it done. And then we do all that before the divorce case is even filed. I know you've done this before too.
Of course.
And we schedule perhaps a mediation, or we have settlement discussions before the case is ever filed, and we're able to reach an agreement during those settlement negotiations or mediation. And now the case is already agreed to. We go file it uncontested with all the settlement documents at the same time, and you're done. That's another way to protect and safeguard your financial assets, because you're spending less time on your case, which is also less attorney's fees.
Yeah.
You're more amicable with your spouse. It's more of like a collaborative, open approach, and that usually results in a really good, fair settlement.
That's right. Because a lot of times I think, so I have a phrase that I tell my clients, I tell our team all the time. A divorce is a fire. Anytime that someone walks into our office, they're on fire. So I want to put water on that fire, not gas. And sometimes litigation alone is just gas on the fire, because discovery, right? So you and I decide what discovery questions we send out. That's not necessarily up to the client. That's an expert issue for those of us that have the expert advice. So yeah, I'm going to ask my client, do you want me to ask about this or that? But the questions I send out are because me and you need that information. And how many times, and we get that in return, and you sit down with your client, why are they asking this? This is insane. Why would they ask this? Does he think I'm having an affair? Da, 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 da. And they just go crazy because, and I said, no, the attorney asked that. Like, I promise you, they did not sit down and say, make sure you ask about this. That's going to get her. This is us doing our due diligence. We're paid to protect you. So we send every question that we might need to gather information to protect you. So sometimes that alone sparks gas on a fire that was almost out, is down to embers, and you just threw a bucket of gasoline on it, not even knowing that you're doing it. And then it's retaliation and it's back and forth. And we've ruined a relationship that was fairly amicable just by doing what we do. If we can get in a situation where we settle these things ahead of time without just the process of litigation is stressful. You and I work really hard to make it as least stressful as possible. And I think we're excellent at that. That's actually one of the things I am most proud about at our firm is how often people tell us, I feel like I don't have to stress about it as much because I know you're handling it. And I love that, but it's still a stressful situation anytime you're in litigation. So if you can reduce that stress or remove it altogether, it's a smart move.
Always. Never a downside to that. Last topic here. I know people are naturally wondering, based on my controversial subject that I brought up, which is, what do you do if you discover that somebody's hiding assets, right? Because that happens, all right? So let's say you're in the middle of your contested divorce, and again, you do a contested divorce and you get served with discovery questions. Discovery is where you get a list of questions you have to answer, list of financial documents you have to produce. I cannot advise you to hide stuff. You are required by law, and I'm supposed to tell you, and I do tell you, you've got to disclose everything that's asked. If they ask for your bank accounts, you got to produce all your bank accounts, all your retirement accounts, disclose all of your assets. Now, let's say you go through the divorce process, you've exchanged discovery, you finalize your case, or maybe you haven't finalized your case yet, but you discover somewhere along the way a piece of evidence that your spouse has intentionally refused or failed to disclose a major asset. Let's say that we've had it happen all the time. We've had it happen while the case is pending. We've had it happen after the case is done. And the good news is you have remedies available.
Right.
If during a case, your spouse is stupid enough, or maybe not stupid enough, they think they're smarter than everybody else, and they roll the dice, and they intentionally fail to disclose something, and it's later discovered, that is great grounds to ask for more than half the assets. It is, I can't tell you how many times I've succeeded in the argument looking at the judge and say, Judge, my client needs to get a much larger share of these assets because, look, here's the proof of what their spouse was hiding. And you see the value of this? What else are they hiding?
Yep.
What else is out there? Judge, all we can divide is what we've got, and we know they're hiding stuff because we found this. So whatever else we haven't found,
what's a liar, always a
but
liar.
my client gets 70% or 80% or whatever of what's here because we know this person's out hiding something.
Yeah.
That's how that can backfire. So my advice is it's not worth it. It ruins your credibility with a court. It ruins your credibility with your spouse, and it can cause you to have a much worse, ironically, much worse case or result in your case as compared to if you had just disclosed the asset to begin with. So my advice to the person trying to hide is don't hide.
Don't hide.
My advice to the person that's been hidden from, you have remedies available even after the divorce. There's a statute that says even after your divorce is finalized, within a certain amount of time, you can come in and set aside that agreement and have the court reopen the proceedings to either get a share of what was not disclosed or have the court readdress the division of all the assets.
But the last thing I'll say about hidden assets, because you and I have harped on how it happened, it's also not common. How often do you have a client come in and say, I know there's more money out there. Go find it. And we do the discovery and we do everything we can and we do the due diligence. We'll even subpoena a bank here and there and it comes back and you're like, there's nothing else there. And it's like, but there has to be. Okay, tell me why you think that. We have to have more money. It's just shocking how many people don't know that as a family, they live beyond their means. So while we do tell you tales that it happens, if we tell you we've exhausted all remedies to try to find hidden accounts or these, this stuff that he's just moving money all around. And I'm like, yeah, okay, but it went from here to here. And then here, if I can do a source of funds tracing and I see that it's just been moved to here and then look, it went to pay off this credit card. You didn't know you had $12,000 on a credit card, but you did. And now here it's paid off. So we can help you try to find them. But if we get to the point that we tell you, I don't think there's anything out there, you're wasting more money trying to look for money that probably really doesn't exist.
That's right. And we can never add more money than what's there. We can only divide what you got. Sometimes people are in bad financial situations and they're like, I can't believe this is all I'm getting.
Yeah.
But we're like, well, this is what you got. We can't add assets to the table. We can talk about alimony maybe if your spouse makes enough money, certainly child support, but we can't create the bank account for you that does not exist. Folks, that's what we've got for protecting your assets in a divorce and how to divide your assets in a divorce. We appreciate you listening to the Oxendine Law Podcast. Don't forget to subscribe on all of your preferred podcast platforms. We're on all the major podcast platforms. We'll give you more insights on navigating divorce and protecting your financial future. If you subscribe, you'll be the first to know about our future episodes. You can ask questions. We will answer them for you. So if you're watching on YouTube, be sure to subscribe, hit the bell for notifications. Until next time, and remember, at Oxendine Law, we play to win.